Well, good afternoon, everyone, and welcome to this second lunchtime talk presented to you by Pump Court Chambers. We have aimed this very much at giving an introductory guide to wills and probate matters, and we're building on the topics that we spoke about last week. Today, I am joined by Victoria Ellis, who's going to be speaking about the important topic of alternative dispute resolution, and Daniella Gilbert, who's going to be looking at some capacity issues. My name is Tara Lyons, and I'm going to be looking at what happens if someone dies before divorce or financial remedies proceedings have been finalised. We're aiming to give this talk over 1 hour, and we're going to aim to leave sufficient time for a few questions at the end. If we don't get time to get to your question, which you can leave in the question and answer function at the bottom of your Zoom screen, then we will endeavour to try and deal with it after the seminar. In terms of the notes for the seminar, we've got them online, and Sean, our fabulous marketing manager, will be sending them to you after the seminar. So I hope everyone can hear me. Let's get started. So when we are thinking about the crossover between claims by a wife or husband in financial remedies proceedings and Inheritance Act claims, it's important to work out at which point the Inheritance Act jurisdiction is invoked. So we're going to look at a number of different scenarios. First of all, so what happens if a party dies after receipt of the judgment, but before it's sealed and before decree absolute? What happens to the application? Well, the Matrimonial Causes Act is very clear that remedies will only be provided by the court upon divorce and not death. So you need to look at MCA 1973, section 23(5), which says where an order is made under this subsection above or after granting of a decree of divorce or nullity of marriage, neither the order nor any settlement made in pursuance of the order shall take effect unless the decree has been made absolute. A decree cannot be sought after the death of a party, and that was made clear in Stanhope and Stanhope. Once death has ended a marriage, it can't be dissolved through the courts, and there's no jurisdiction to hear an application for ancillary relief after the death of the parties. So unfortunately, if there's no decree absolute, you can't get your financial remedies order. What if the party has died after decree absolute and after the judgment has been delivered to the parties but not sealed? Well, the courts have made clear that that order would still be enforceable. You need to look at the case of McMinn and McMinn and the helpful words of Mrs. Justice Black in that case, which makes clear it's not necessary that either the order has been formally typed up or sealed. So in that scenario, you can get your final consent order or judgment. What if the financial remedies have been concluded and then a party has died? Well, in that situation, you've got your order, and so you're looking at what the implications of the death of a former spouse means. Now, it doesn't automatically invalidate the original financial remedies proceedings. However, a party may seek to set aside the order on the basis of a barter event, a supervening event that invalidates the fundamental assumption on which the order was made. Barter and Barter is that well-known authority. It's a 1987 case. And the questions that the court will look at is, did the new event invalidate the fundamental assumption on which the order was made, so that if leave were given, the appeal would be certain or very likely to succeed. Did the new event occur within a relatively short period of time? And usually we're thinking about a period of less than a year after the order was made. And has the application for leave to appeal out of time been made promptly? And does the application prejudice third parties who have acquired in good faith and for valuable consideration interests in the property? There have been a number of cases in which it was argued that the death of a party was a good reason to set aside and it constituted a barred event, and I've set those out there for you. In all cases, save for the case of Richardson, death did amount to a barred event which had not been reasonably foreseeable. However, a note of caution, a barred event is only likely to be arguable when the original award was needs-based and that need no longer exists. So, what if a party dies before a financial settlement or order is reached? Well, in that scenario, you are going to be looking at that party bringing a claim under the Inheritance Family Independence Act 1975. Now, commonly known as the 1975 Act, and Jack Rundell gave you a brief introduction to that act on the last occasion. Just to recap, in order to be eligible to bring a claim under the 1975 Act, the deceased must be domiciled in England and Wales at the date of death. Now, obviously, when you're dealing with financial remedies proceedings, the domicile per se is not something that you're necessarily going to have in mind, but if the wife becomes a widow, then domicile becomes incredibly important. And there are often preliminary hearings dealing just solely with the issue of domicile, which can be more costly, expensive and lengthy than the actual 1975 Act claim itself. So it's important to get a grip on domicile and understand its relevance. The claimant must also, in addition to the deceased being domiciled in England and Wales, the claimant must also fall into one of the recognised categories of claimant, which I know that Jack took you through. But for these purposes, the relevant categories are spouse, former spouse, and I'm also going to say cohabitee, and that's following a case of Chekhov and Fryer, which we'll have a look at in a moment. There are different standards of provision for a spouse and former spouse under the 1975 Act. And so it is important to work out whether we are dealing with a spouse. Has decree absolute been pronounced yet? In which case you'd be dealing with a former spouse. However, Section 14 of the 1975 Act gives a former spouse a period of grace in which he or she could claim and receive the same provision as a spouse. Essentially, it allows a former spouse, if an application is made within 12 months of the date of the decree absolute, to claim effectively as a spouse and receive the same provision. So that's a really important thing when you're representing a wife or a husband that's become a widow or widower, to think, well, actually, do we have an option to bring this as essentially a spouse under Section 14? If so, we've got to act very quickly and we've got to make the application before the 12 months are up. So I spoke about the two different standards of provision. I'm sure Jack went over this, but a spouse or civil partner gets what's called the golden standard, the special standard of provision, which is such financial provision as would be reasonable in all the circumstances of the case for a husband or wife to receive, whether or not that provision is required for his or her maintenance. And all other claimants, which would include the former spouse, subject to the Section 14, which we've just looked at, is just such financial provision as it would be reasonable in all the circumstances of the case for the applicant to receive for his maintenance. So it's limited to the maintenance test. Now, in deciding whether or not reasonable financial provision has been made, the court asks itself the objective question of whether the estate failed to make reasonable financial provision. If the answer is yes, then the court must work out what reasonable financial provision would be. Now, in either course, the court is directed to look at the Section 3 factors. Now, in the case of the spouse, and I know that Jack has gone through these factors, in the case of the spouse, in addition to the general considerations, which I've set out there and which I'm sure you've heard before, there are also the specific considerations under Section 3.2. Now, they are the age of the applicant, the duration of the marriage or civil partnership, and the contribution made by the applicant to the welfare of the family. And lastly, the divorce hypothesis. So the divorce hypothesis is set out at Section 3.2. In the case of an application by the wife or husband of the deceased, the court shall also, unless at the date of death a decree of judicial separation was in force and the separation was continuing, have regard to provision which the applicant might reasonably have been expected to receive if on the day in which the deceased died, the marriage, instead of being terminated by death, had been terminated by a decree of divorce. Now, under the Inheritance and Trustees Act 2014, new words were inserted into this to say, but nothing requires the court to treat such provision as setting an upper or lower limit on the provision which may be made by an order under Section 2. So the divorce hypothesis, and we see it time and time again in cases and now reinforced in the statute itself, is neither a ceiling for the reasonable provision that a spouse could expect to receive, nor is it a floor. And that was made very clear in the case of Probate, who also, the court also emphasised in that case that the divorce fiction is just but one of the factors. Of course, when you're dealing with a spouse who has got so far in financial remedies proceedings, the divorce fiction can become a very important factor, but it is always important to remember that it is just one factor. Now, in P&G and P&P, the court recognised that the divorce fiction is a bit of a blunt tool, because what the court said in that case was, I'm struck by the force of the repeated observations in the decided authorities about the difference between divorce, where there are two surviving spouses for whom to make provision, and death, where there is only one. It seems to me probable that this difference will not infrequently be reflected in greater provision being made under the 1975 Act than would have been made on divorce, and that this may legitimately be so even where the estate is relatively large, as is here. So the first difficulty with applying the divorce fiction as a straitjacket is, of course, it's like comparing apples and pears. You're dealing with, on death, one surviving spouse, on divorce, two spouses, and of course, their needs take precedence. The second difference is, of course, that actually death brings with it a change in the financial circumstances of the parties or the remaining or the remaining spouse. For instance, on death, you might lose a really valuable income stream. However, you might also gain capital in the form of death and service benefits or the like. So it's never an exact comparison. And that was again reinforced in the case of Fielden and Cunliffe. Now, I just want to give you, I think Fielden and Cunliffe is a really good example of how the divorce fiction shouldn't ever be viewed as a ceiling, because in this case, the court was concerned with a one-year marriage, and the estate comprised assets that the deceased had pre-inherited or acquired before the marriage. Now, whilst these were material considerations for the court, the widow still managed to recover a substantial award of £600,000 from an estate of 1.4 million. And that was based on her need for housing, which the court said was 200,000, and her maintenance need. And this is where really the case differed from a financial remedies outcome, because this very young widow, who had longer to live and so longer to meet her income needs going forward, received a pretty hefty maintenance claim. When you compare that an elderly widow who might have been married to the same husband for longer, given that they only had fewer years left to live, might have received much less. So it was a perversity. But she essentially got a Duxbury income fund of 30,000 per year, which was rounded up to 400,000. So that explains how she achieved significantly more than she would have done on divorce. Some other cases to look at when you're looking at how the courts apply the divorce fiction are these. Iqbal and Ahmed was a case involving very small money, and the wife or widow had lived with her husband, for the deceased, for 20 years. They lived in a property that the deceased had owned from a previous marriage. The property was worth about 115,000, and there was a residue of about 28,000. The widow made a claim against the estate for a greater interest in the house. She'd just been left a life interest in the property, and at first instance she secured an outright interest of 50% of the home and a life interest in the remaining 50%, together with the residuary estate. So already more than she would have achieved on divorce. The son appealed, arguing that the life interest in the whole of the property was more than sufficient provision. Now, what the court did is in applying the words of Lord Nichols in Miller and Miller, where he references the importance of the family home. He says the party's matrimonial home, even if it was brought into the marriage at the outset by one of the parties, usually has a central place in any marriage. The court ignored arguments that the home was premarital, treated it as marital property, and found that in addition to needing to be able to live in the property, she also needed to have a capital interest in the property, so that she could, if needed, liquidate it to meet care home costs. She needed the residue to meet any additional capital needs above and beyond her housing. So that was a really good illustration of the greater provision, again, under the 1975 Act. Now, when we have a bigger money case, such as in Lillyman and Lillyman, in fact, what we do tend to see is the courts are more likely to consider the divorce fiction a lot more carefully, because, of course, there's no significant needs argument, which gets you over and above what would be provided for upon divorce. And in Lillyman and Lillyman, I think we were dealing with assets of over £5 million. And the court applied, when looking at a company that was owned by the deceased, the court applied a very slavish sort of comparison to cases like N&F and Jones and Jones, and gave the spouse exactly half of what was considered to be the marital assets, but of course it was half of quite a large chunk, and so that more than met her needs. In the case of Berger and Berger, this was actually a case about permission to appeal out of time, and the court made some comments there about the fact that actually generally when you're thinking about spouse claims, you are looking at outright provision rather than life interest provision. Now, if you're thinking about former spouse claims or other categories of applicant, then you may be looking at life interests instead. So Berger and Berger just has some useful commentary on that. Former spouse, well, eligibility should be very easy to determine after decree absolute. But in order for a party to claim as a former spouse, they must not have got remarried before the death of the deceased. So that's just an important thing to bear in mind. And the other thing you've got to bear in mind is you've got to check that there hasn't been an order restricting an application. And you need to have in mind section 15 of the Act, which makes clear that if there's been an order, for example, in a consent order or final order of the court, which prevents a party from applying on death, then the Inheritance Act claim should not be entertained. Now, there was quite an ingenious way round that provision in the case of Chekhov and Fryer, which was a case in which two colleagues of ours, Amy Berry, who you've heard from last week, and Mark Dubbery, appeared against each other. And in that case, Amy was arguing that actually the claim by her client should not be debarred, because in addition to being able to argue it as a former spouse, she could also argue it as a cohabitee, having remained living with her former husband for some time after the divorce. And much to Mark's chagrin, Amy was successful in this argument, and the court found that it did not preclude the former spouse from applying at all. It just precluded her from applying under the category of a former spouse. That was no great loss to her, because of course the provision as a former spouse, or the standard applied as a former spouse, was exactly the same as a standard as a cohabitee. So a resounding victory for Amy. Just to bear in mind, when you are considering looking at a 1975 Act claim, that actually you are needing to be aware of the clock, because you have 6 months from the date of the grant of probate to make an application. And whilst the court can give you permission to apply out of time, that involves additional cost, and it's a hugely discretionary area. So you'll have cases such as Busati and Patel, in which Mark Dubbery appeared in again, in which he successfully argued that an application could be made by a spouse over 20 years after the grant of probate. That was exceptionally unusual. And then you have Cowan and Foreman, in which a spouse was not given permission 3 years after. So it's a risky thing, and it's much better to apply your thoughts to the time limit and make your application in time. Just a couple of other points, of course. Unlike your financial remedies proceedings, you're dealing with the CPR, and you're making an application by Part 8. So you need to have well, read Part 8 of the CPR to look at the key considerations. And if you're dealing with a spouse claim, although you'll be making your application to the High Court, you normally want to proceed in the family division because they're so well versed in the divorce fiction. You can make your application before grant, and that's clear under Part 57, 16.3a of the CPR. And I've just set out here some other thoughts of interim applications or requests you want to be making to the other side in advance of the claim. I'll let you have a read of that, but always seek an undertaking that they're not going to distribute the estate. Finally, costs are at large in proceedings. Unlike financial remedies proceedings, the usual rule is the costs follow the event. So important to think of protecting your client with Part 36 offers, and of course cost budgeting comes into the equation. Right, I'm going to pass on to Daniella Gilbert now, who's going to be speaking about capacity.
There we go. All right. So I'm going to be talking about how the courts treat capacity, specifically testamentary capacity. For those who joined us last week, or joined others, not myself, Amy Berry will have given you a brief introduction to the issue of capacity in the context of the validity of a will. We're going to go today into a bit more detail on the specific issue of capacity. I should say, with a caveat, we all love those, it's still not a completely comprehensive guide to the issue of capacity. There's some areas that we're just not going to have time to cover, but basically this is your basic principles and your starter guide. So the first question is, what does capacity mean? What is required for someone to have testamentary capacity? And we start with the common law test, which was set down in Banks and Goodfellow as long ago as 1870. So that is essentially the test for capacity without which a will not be valid. And you'll see there that I've set out 3 bullet points relating to what a testator must have. They must understand the nature of their act, i.e. that they're making a will and the effects of it. They must understand the extent of the property that they are disposing of by virtue of the will. And they must comprehend and appreciate the claims to which they ought to give effect. And that essentially means understanding, comprehending the claims of people that they do intend to include, and also those that they intend to exclude. And you'll see that there's a 4th point there. The testator must not be subject to any disorder of mind or insane delusion, as shall poison his affections, pervert his sense of right, or prevent the exercise of his natural faculties. Now, that is actually a 4th point. I've set it out separately for this reason. There is something of a debate, or at least there was, about whether this is a separate 4th limb of the test. So in Banks, it was treated as simply an aspect of the 3rd limb, so relevant to whether a testator comprehended and understood the claims that they perhaps ought to give effect to. However, more recent authorities have treated it as a separate limb. So we've got there Sharp and Adam and Costick and Chaplin. So if it's a separate limb, then essentially it could affect the determination of the others. For example, in Theobald on Wills, they give a fairly entertaining example of perhaps a testator who believes that a part of the property that they are disposing of, for example, the family home, might be blighted by some evil supernatural influence. So if a testator has that sort of delusion, and it could affect the 1st limb or the 2nd limb of the Banks test. But the key point for our purposes here is that it can be, this fourth limb can be a standalone test. So for example, in Sharp and Adam, limbs 1 to 3 of the Banks test were satisfied, but limb 4 was not. Essentially, the court finding that the testator's mind had been poisoned, the natural affection he felt for his daughters had been poisoned by a disorder of the mind. And so the will was not upheld. So the true test is whether a disorder of the mind has brought about the disposition of the testator's estate, which would not otherwise have been made. And whilst it seems to be fairly clear now from Sharp and Adam and Costinck and Chaplin that that is the way that it should be approached, I highlight the discrepancy because in the case of Clitheroe, which we're going to come on to shortly, the court referenced the debate but didn't need to deal with it. So it may come to life again in future. Some other points to note about what capacity does and doesn't mean. Potential capacity to understand is not to be equated with memory. That's Simon and Byford. Now, in that case, the deceased had mild to moderate dementia. An earlier will that she had made left a greater share to one of her children because of, amongst other reasons, the assistance that he had given her. But the court held that it was not a memory test. She needed to understand what she was doing by virtue of the later will. She didn't need to remember prior reasons for having made different provision in the past. The second point there, also from Simon and Byford, is that the requirement that a testator understands what they are disposing of by way of the will is limited to the extent of their property. So it doesn't extend to the collateral consequences. So again, in Simon and Byford, there was a disposition of shares in the family company. And essentially, in the later will, they were shared equally, which meant that there was a possibility of deadlock in the company. Now, the prior will had been arranged so as to avoid that, but the court held that the deceased did not need to understand the potential collateral consequences of disposing of the shares in the way she did, merely the effect of it and what shares she had. She also didn't need to understand the significance of that property to other people. And finally, the power of rational decision-making, key being the key case here, in which the court noted never a widening range of circumstances being recognised by psychiatric medicine as giving rise to a risk of mental disorder, which could deprive a person of the power of rational decision-making. So not just the impact of old age and infirmity, but other affective disorders such as depression, in that case having been caused by the very recent bereavement of the deceased's wife. And it was held that in conjunction with other cognitive impairments he had, that was sufficient to show that he didn't have capacity, although in fact the court would have held that his depression of itself would have been sufficient to deprive him of capacity. So now that we know what capacity means under the common law test, what's the relevance of the Mental Capacity Act 2005? I've just set out, and I shall skip through them fairly quickly, sections 1, 2 and 3, which are really the key sections of the MCA for our purposes. And I'll highlight there subsection 2, a person must be assumed to have capacity unless it's established that he lacks capacity. So straight away, we've got from the outset a presumption of capacity. Section 2, for the purposes of this Act, a person lacks capacity in relation to a matter if at the material time he's unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. And a highlight there for the purposes of this Act, because that's going to become relevant in a moment. And section 3, where we set out specifically when somebody will not have capacity, For the purposes of section 2, a person is unable to make a decision for himself if he is unable to understand the information relevant to the decision, to retain that information, to use or weigh that information as part of a process of making the decision, or to communicate his decision, whether by using talking, sign language, or other means. And there's some extra provisions there that is worth having a look at. So is it consistent with the common law test? Potentially no. We've got Walker and Badman in 2014 identified a number of potential differences between the tests. So for example, the presumption of capacity, which I emphasised earlier, under the MCA, there is a presumption from the outset, and that's not the case under the common law test, especially in relation to the burden of proof, which I'm going to come back to a little bit later. The second difference, the requirements in section 3.1 relating to the degree of understanding and retention of relevant information, which could require more than the common law test. So go back in contrast Simon and Byford, where it was held that memory isn't relevant. And number 3, the requirements in section 3.1 when read with section 3.4 relating to understanding the consequences of the choices available. Again, we refer back to Simon and Byford. Appreciating the extent of the property is what is key, not the consequences of disposing of it in the way that they have chosen to do. So Walker and Badman held that the MCA test did not apply and the common law test was the correct one. It highlighted, as I did a moment ago, that the MCA applies for the purposes of this Act, i.e. to define the circumstances in which living people are able to take decisions, and if they can't, how decisions are to be taken for them. It's not retrospective. And in that case, it was held that the principle of statutory interpretation that Parliament is assumed not to intend to overrule well-established rules of common law without clear words applied. Indeed, this is a rule that's existed for a few hundred years, and there was no clear intention to override that. More recently, that decision has been reaffirmed. We have James and James in 2018, in which it was said that the Banks and Goodfellow test remains the sole test for capacity. Again, reaffirmed that the individual provisions of the Act were concerned with assessing living people and their capacity, not making retrospective judgments. And very recently, Clitheroe and Bond. Again, affirmed Walker and Badman and James and James. This is a case that related to a mother who had disinherited her daughter in a will that was made not too long before she passed away. If you have time, I really recommend reading this judgment in full. It's interesting, but it also gives a really thorough consideration of this point. So in addition to the reasons held in Walker and Badman and James, Mr. Justice Falk talked about the application of the Code of Practice attached to the Mental Capacity Act. And in particular, the paragraph 4.32 explicitly refers to the existence of the common law test and including the Banks test. It reaffirmed that the Act's new definition of capacity is in line with those existing common law tests and doesn't replace them. When cases come before the court on the issues under the MCA, judges can adopt the new definition if they think it is appropriate. But by reference to that, in Local Authority X and MM, the reference to appropriate in that context was for judges deciding capacity issues outside of the Court of Protection. It meant having regard to the existing principles of common law. So one could apply it if there was no inconsistency, but if there is, then one should be applying the common law rule. So where does that leave us? Well, there's a potential problem, one of which was highlighted in the Chancery Bar Association's response to the Law Commission consultation paper in 2017. And it's worth noting that that consultation has been paused for the moment. But what was pointed out was that in an extreme scenario, you could have a situation where there was no valid will because a testator lacked, it was held that a testator lacked capacity under the bank's test after he deceased, but was not demonstrated to lack capacity for the MCA purposes. So you end up in sort of a catch-22 situation. However, in Clitheroe, it was held that without a clearer determination of any substantive differences, it's not possible to say whether in reality that's a theoretical problem or a practical problem. And if it is a problem, it's for Parliament to resolve, not the courts. So now that we know what capacity is, who has the burden? The initial burden is always on the propounder of the will. However, that's not a high burden to reach. If a will is rational on its face, if it's properly executed and attested to, then the presumption will arise. However, what sort of evidence do we need to rebut that presumption? Well, there is the shifting burden as set out in Key and Key, and sort of summarised really the principle, where the burden starts at the propounder of a will to establish capacity. Where the will is duly executed and appears rational, the court will presume capacity. In such a case, the evidential burden then shifts the objector to raise a real doubt. And if a real doubt is raised, the evidential burden will then shift back to the propounder to establish capacity nonetheless. So what circumstances will and won't raise capacity as an issue and then prove it? Well, in Burgess and Hawes, where a will is prepared by an experienced solicitor, as they often are, who was read through and explained it to the testator, and who had the view at the time that the testator had capacity, that might provide strong evidence. That evidence will be even stronger where they've kept a detailed attendance note of those meetings. And those notes show that the testator understood the nature of the act and its effects. Where an experienced lawyer has formed the view from those meetings that the testator had capacity, then again, that's clear evidence. But, and this is a note of caution, any view that the solicitor has as to capacity must be shown to be based on a proper assessment and accurate information, or it's worthless. So what does that mean? In practical terms, one needs to think about how many times that solicitor met the deceased. Would they have been likely to be able to pick up on any issues with capacity from just that one meeting, if it was that one meeting? Did the solicitor meet them potentially on good days, which were few and far between? Was there any influence of the bad days? What types of question and what style of interview technique did they use? It's generally thought that using open questions is better in those circumstances. But these are things to bear in mind if one is thinking about challenging capacity retrospectively. And if a solicitor is in doubt, the golden rule. Summarised more recently in Key and Key, the substance of the golden rule is that when a solicitor is instructed to prepare a will for an aged testator or for one who has been seriously ill, he should arrange for a medical practitioner first to satisfy himself as to the capacity and understanding of the testator and to make a contemporaneous record of his examination and findings. It's not a rule of law, but it's a very good guide and good practice. And finally, when must capacity be determined? Well, the general rule is that they must have capacity at the time they execute the will. Again, that goes back to Banks. There's a single exception, Parker and Felgate. A testator who lacks capacity at the time of execution may make a valid will if the testator has testamentary capacity at the time when he gives instructions. The will is prepared so as to give effect to those instructions. The will, as prepared, continues to reflect the testator's intentions, and at the time of execution, the testator understands that they are executing a will for which they have given instructions. Okay, so that was your sort of whistle-stop tour. There are other areas which you might want to have a look at. For example, degree of capacity. So is it relative? And for example, if there is capacity in relation to some parts of the will but not others, those are other areas you might want to have a look at if you're delving more deeply into this. Right, I'm going to hand you over now to Victoria Ellis.
Right, my talk really to round off two excellent talks from your previous speakers is to have a quick look with you through the issue of ADR and mediation in this area of law, particularly the various types that you have available to you and the cost consequences if you decide not to avail yourself of the various potential options. So what is alternative dispute resolution? It's any way in which the parties can try and agree their issue and their disputes outside of the court arena. So you have your standard discussion and negotiations, mediation, early neutral evaluation, and arbitration. And we'll come on to look at those all a little bit individually in a moment. But it's worth noting that the parties can agree to stay the proceedings at any stage in order to try and resolve the matters by ADR if they want to, and often will be encouraged to do so by the court. So mediation. This is when you have the parties and their advisors, if they want them there, all attend the same location, normally with about a day allocated, and they try and see if they can hammer out a resolution to the problem. The costs of this are going to be much less than full-scale litigation. Zoom and Teams also works well. Obviously, in the post-pandemic era that we're in, we've had to adapt, and mediations, turns out, do work well over Zoom and Teams. And it's also a very helpful tool if you have a family member or somebody who's involved who lives further away or abroad and cannot make the actual mediation day themselves. You can include them and you can have them as part of the day by having them on a virtual app. It's confidential and it's on a without prejudice basis. There is no determination at the end of the day. The mediator will do their best, they'll roll up their sleeves, but no one's going to impose an outcome on the parties, so they can walk away if they choose to. Mediation is the most common form of ADR in relation to these sorts of proceedings, and there's lots of reasons for that, but in addition to all the legal reasons, you have the very practical reasons. Often you're dealing with families who are very raw, they've gone through a difficult and emotional time, and sometimes a lot of the difficulties can be because of family dynamics, hurt feelings, relationships that have gone sour, and a mediation sometimes gives you the forum in which to try and address those issues, which often are not things the court is going to get involved with themselves. In terms of arbitration, this is slightly different to mediation. You appoint an arbitrator and you enter a binding agreement to arbitrate. The parties have some flexibility about choosing who that arbitrator is and the sort of rules that are going to run the day. However, it does mean that there is a binding award made at the end of it, and it's only appealable in certain circumstances, so you do have some finality. Early neutral evaluation is something that you may not have heard of before, and if any of you do family law, it's a bit of akin to FDR proceedings. There are some differences, but it's a similar sort of beast. It's really mainly appropriate when you don't have significant issues of fact or law that are going to need to be determined by the court. And what it means is that an independent evaluator, potentially a judge, can look at the papers, have a really good think about it, and then give quite a frank assessment to the parties of the strength and weaknesses of their case. Again, it's non-binding, it's without prejudice, and you're going to have an evaluator who's a specialist in their area. Sometimes if they hear from a judge or somebody who's a real specialist that their case is good on these parts, bad on others, it may actually invoke some sort of compromise between the parties. It can be a voluntary process. What is really important to remember, as set out in this slide, is the court does have the power to order the parties to undergo this as part of their case management powers. Why is it important? Well, the courts is a growing trend to try and encourage people to settle litigation by way of ADR. You've got the Justice ADR Handbook that makes this very clear. You've got the Chancery Guides and you've got the CPR. And really the idea is to try and resolve matters outside of court wherever possible, to decrease the burden on the court, to deal with cases justly and proportionately cost-wise. And also because in the field that we're talking about, you're going to want to try and preserve those family relationships if at all possible. It should have been considered before you get to proceeding stage. You have the practice direction on pre-action conduct, which makes it very clear Proceedings should be a last resort, we all know that. ADR is not compulsory, but parties really need to think about whether it will help them resolve matters. And a court may be very interested later on down the line as to whether or not the parties have considered ADR. And the reason for that is that there can be cost consequences if a party unreasonably refuses to take part in ADR. Now, normally costs follow the event, but the court would have the power to do whatever it wished in terms of trying to do sanctions and penalties. And you can see the list of things they can do there. They can order the party at fault to pay the cost of the proceedings. They can order them to pay some of the cost of the other party. They can do that on an indemnity basis, and they can make sanctions involving interest. To be very clear, unreasonably refusing or ignoring an offer to mediate is probably going to be seen as non-compliant behaviour. There's a couple of key cases in this area that you're going to want to take note of, and the first is going to be Halsey. Now, Halsey is a must-read if you're doing anything in relation to ADR and sanctions. It sets out really helpful guidance from the court as to what should happen in these scenarios. It was the case that considered whether cost sanctions should be applied against a successful litigant, but on the grounds that they had refused to take part in ADR. Now, whilst the person in this case got away with it, the court did set out the circumstances in which they might go further and make such sanctions. Now, we all know that the fundamental principle is that sometimes the loser pays, costs follow the event, but this can change if you've been found to have messed around and been unreasonable in ADR. What the Court of Appeal said is that there are certain factors that should be considered: the nature of the dispute, the merits, the failure of other settlement attempts, the cost of mediation being disproportionate, delay, the prospect that ADR will succeed. Now, there's a couple of other cases I'm going to take you through, because what I can say is that, a bit like excuses when you don't do your homework, there have been numerous litigants who've now tried to give those excuses to the courts, and they haven't gone very well, because the courts tend to take the view that it's going to be a rare case that ADR would be completely inappropriate for. So this is the first case you need to have a look at. And I've got to say, pretty bold tactics here. What happened is the Court of Appeal upheld a decision to disallow a successful defendant the costs he would have been entitled to. And the reason they did that was because of all the things that have gone on behind the scenes in the lead up to the case. And in particular, there was a letter. And they were very concerned about the way people have acted. And what they say is this: that silence in the face of an invitation to participate in ADR is a general rule of itself unreasonable, regardless of whether the outright refusal or refusals to engage in the type of ADR requested or to do so at the time requested may have been justified by identification of reasonable grounds. So when you have one party sending lots of letters saying, let's try and mediate, let's try and do ADR, let's try and resolve this, if you just ignore it because you are justified that you are right, or you decide it's just not relevant, you're not going to bother, you are probably going to find yourself in some hot water. If you think you do have a good reason not to engage, then it's been set out of the Jackson Handbook, and I've given you the quotes to have a good look at, then you need to act appropriately. You don't ignore the request. You respond promptly in writing so that you can show that you have, and give the reasons why you don't think ADR is appropriate at this stage. If you can use the Halsey guidelines and some of those reasons, do it. And particularly if it's a case of you just don't have the information yet to assess the case, then say so. Say what you need, say what's missing, and give a solution to how you can resolve that. Don't just close off ADR of any kind for all time. And the example of what not to do is in Garrett and Critchley, and the case I've set out here. Because in this case, claimants sought $208,000. Defendants felt very confident that they didn't need to engage with this, and it's a case that was going nowhere, and they completely failed to engage in ADR. And what they say is interesting. And it's interesting because their approach was so robust that the judges decide that they want to quote some of their correspondence. Particularly, both we and our clients are well aware of the penalties the court may seek to impose if we are unreasonably found to refuse to mediation. But we are confident that in a matter in which our clients are extremely confident of their position and do not consider there is a realistic prospect that your client will succeed, the rejection is entirely reasonable. Well, the claimant offered to settle for £10,000, but the case went to trial. And after the trial, but before judgment, the defendants decided to accept that £10,000 plus standard basis costs. The claimants sought all of their costs on indemnity basis. The defendants sought to justify their refusal to mediate on the grounds that the parties were too far apart, they didn't like each other, and proportionality. And none of those really held much weight with the judge, who said this: parties don't know whether in truth they are too far apart to sit down and explore settlement until they sit down and do it. If they're too irreconcilably far apart, the mediator will say as much from the first hour of mediation, but that happens very rarely. And he made some good points. Even if liability issues are binary, there's going to be a range of quantum issues that you're going to want to explore. Judges are going to assess the credibility of your witnesses, and we all know that the strongest cases can fall on witnesses being useless, and the worst cases can be bolstered by a good witness getting in the box, and that alone should make you do a risk assessment. So the defendants were ordered to pay the costs and on an indemnity basis. Now, Laporte versus the Commissioner is quite a nice case, and if you're getting into this, have a read of this, because it summarises a lot of the big cases that came before it and setting out the guidelines. So it's quite a nice introductory case to read. And this is a case in which you almost feel such sympathy in a way for the solicitor dealing with this for the police, who just is overwhelmed. And every time she gets a letter, she misses it, or she misses deadlines, she doesn't respond promptly. And the other side are chasing and chasing and chasing in order to be able to get them to come to ADR, and they just don't do it. And despite the fact that it wasn't necessarily a blanket, this is ridiculous, we're not playing ball, it was just, it didn't happen, they didn't engage, they didn't arrange ADR, and they were penalised for that. Because even though the defendant was successful, they only got 2/3 of their costs. And again, the court re-emphasised that if you've got to engage, if you're not going to engage, you have to say why. You can't just ignore the other side. In the case above here, in OMV Petram versus Glencore, you've got Sir Geoffrey Voss, and he gives some really important points as well. Parties are obliged to conduct litigation collaboratively and to engage constructively in a settlement process. A blank refusal to engage in negotiating or mediation processes to reach a compromise should be marked with the use of the court's power to discourage such conduct. And this goes on to the case of Patel. You know that we've got to obviously engage. We've made that point, I've hammered it home, but you have to be real. You can't just drag your feet and give the superficial appearance that you're engaging. And that's what happens in Thacker and Patel. The defendants did not ignore or refuse the offer, but they dragged their feet, they delayed, they messed around, they had spurious reasons for things not happening, until eventually the claimants reasonably lost complete confidence in the whole process of ADR. And the judge reflected that and said, if one party is frustrating and dragging their feet for no good reason, there will still be cost sanctions because you have actually prevented the ADR taking place. So the defendants were ordered to pay 75% of the claimant's cost of the claim, with the claimants paying the defendant's costs. And it's a real telling off, really, of a judge saying, you have to do this properly, you can't mess around. In the recent case of Burgess and Penny, this is interesting for lots of reasons. It got lots of press attention. And it's two sisters who wanted to fight the will their mother had left, that said that her estate would be split equally between her 3 children, the 2 sisters and their brother. And the press seemed to believe this was because the brother was a lot richer than the sisters, and they thought it was all very unfair. It's an interesting case for many reasons, but the nugget to take away from this is the fact that the sisters completely refused to mediate. And what the court said about it was this: it all boiled down to the fact that the sisters wanted an admission from their brother. They felt he'd behaved badly, they felt that he'd done them wrong, and they wanted him to acknowledge that and to recognise that. And this is actually when mediation becomes very relevant, because mediation is going to be much more able to try and repair those relationships and elicit some sort of compromise and recognition than a court who's not going to get into who did what to whom years ago. And the court emphasised that mediation isn't just about one side getting their own way. That's a complete misconception. You've got to go into it thinking, we've got to try and settle this. And we often say to clients, look, neither of you are going to skip out of here happy if you settle, but you're going to both walk away thinking you can live with it and it's okay. And that's sort of the test of a good mediation or compromise. And the judge really rammed home the fact that actually you need to think about what the stumbling block is preventing your parties settling. Oh, I've just skipped a page, apologies. In the last case here, again, you have a really good example of just losing confidence in the process. There'd already been 2 attempts to resolve. The son had every time he'd refused to honour the mediation agreement, and when they came back again and said, look, let's try alternative dispute resolution for the 3rd time, and the defendant said, no, I'm done, I don't want more costs, I don't want more broken promises, the court found that that was a reasonable reason to refuse. So the courts aren't always going to say that refusal is inappropriate, but you're going to have good reasons for doing that. Preparation. Bundles need to be prepared in good time, and We only need the essential documents. It's not a trial bundle. It's not going to be fully litigated. You need your core documents, you need your core facts and figures. Position statements, try and keep them concise, essential facts and arguments. And if there's a solution that you think you're looking for, an outcome that you want to reach, set it out in the position statement. You're going to choose a mediator who knows their stuff. So give them the time to be able to help you. Give them the time to make sure they've got everything in sufficient advance so they can read the papers, they can digest them, they can analyse the good bits and the bad bits, and potentially identify stumbling blocks and ways around them. Make sure you're ready with your cost to date and estimated cost of trial, because you may need that. And I've been in more than one mediation when people are seeking their cost to date and we don't have cost schedules, and that doesn't help anybody. Think about your logistics. As I've said, if parties can't appear, you can have them virtually now. It's much more common now that we are in a post-COVID world, and we all know about Zoom and Teams. A joint opening session. Take a view on this. Sometimes it's really helpful, so parties feel that they've had their say, they've set out what their position is to the other side. It can be really helpful for a mediator to address both parties and say, look, you're here to compromise. I'm not here to judge. I'm not here to take sides. I'm here to try and help you. But look at your family dynamics. If putting people in a room together is just going to cause a massive catfight at the start of the day, maybe avoid it and have separate sessions with the mediator. And make sure your clients know that in order to succeed, they're going to have to compromise. Don't let that be a shock for the mediator to tell them when you get in there. During your mediation, if there's information that you need, ask for it. If the other side are asking reasonable questions, try and answer them. Sometimes silly things can be the key to solving your case. Very recently, it turned out, despite the squabbling, it all came down to the fact that Dad had made these beautiful model aeroplanes and they all wanted them for their children to inherit. And that became a real big bugbear. And once we got past that, actually things fell into place relatively quickly. If you're making offers, they've got to be realistic. Yes, they're going to be tactical. You're not going to give everything away at the beginning of the day, but don't alienate or try not to alienate the other side by asking for ridiculous things. You have more power and options to try and shape a settlement, and the court do mediation, so utilise them if you can. And what I will say this is, don't underestimate the importance of the practicalities of the day. People are getting emotional, they're getting stressed, take a break. 15-minute break can make all the difference. People can calm down and come back more focused. Have food and snacks and drinks, because it's going to be a long day and you're going to need them. Have chargers with you, because things are going to run out of battery. Do not underestimate how long it will take to draft the agreement. I always go into mine with a basic draft already done, with all of the details and all the bank accounts and all the property details. Obviously, you'll have to amend it on the day, but the detail can make or break the agreement. And try not to leave, or let the mediator leave, importantly, until you have a signed deal. Not always possible. There are times when it can't happen, but if you're going to try and deal with it that day, get it all signed before you leave. And try to avoid reporting back. There is nothing worse than having reached an agreement and then people phone home to tell everybody what they've done, and then great Aunt Susan and Uncle Roger put their oar in, and all of a sudden everything falls apart because somebody else has said something really unhelpful. Costs. Each party should pay their own costs unless otherwise negotiated, and the parties should equally meet the costs of the venue and the mediator if they can, because having an investment in the process, having had to pay for this, can be really psychologically an important thing to happen. Now, I appreciate that I have done a whistle-stop tour through that because of the much more talks before mine. But if you have any questions, we have a fantastic mediation, arbitration team within Pump Court. There's lots of people that can help you to represent you or to be your mediators or arbitrators. So never be afraid to pick up the phone if you have a question. I think there might be a question. I'll ask the others who've been monitoring it while I've been talking.
Yes. Thank you, Victoria. We've got we've got one question, which is it considered to be unreasonable if a defendant refuses to mediate as he'll only accept the decision of a judge? I'm sure Victoria will probably agree with me if I say, yes, it is very likely that that would be considered unreasonable, because Inheritance Act and probate disputes are the sorts of disputes that are thought to be ideally suited to mediation, and if every party used that as an excuse, they'd never mediate at all. So absolutely, I think that would be unreasonable. If anyone has any other questions, please don't hesitate to email us afterwards. I think we've run out of time, and apologies for my part in that. Thank you very much, everyone, for attending. It's been a pleasure, and we'll see you all soon.